So very good evening, all the participants.
Yes, sir. Good evening.
Today we'll be doing the case studies on voluntary liquidation. But before we start the case studies, let us do a question answer session for 5-10 minutes, just for the basic understanding of the provisions. So I would request Lokesh ji to please list out the points which will be covered in the declaration. Lokesh ji,
Yes,
what
sir.
are the points to be covered in the declaration?
Yes, that they have made a full inquiry into the affairs of the corporate person.
Right. This is the first point.
Yes. And
Second
then
point?
it should not be to defraud any person.
Right.
This voluntary liquidation should not be to defraud any person.
Right.
Then they have made a sufficient provision to meet the debt obligations, all the debt obligations.
Right. And fourth
And
point?
fourth point is that they have made sufficient provision to meet the obligations causing after the liquidation.
वो तो
और
हो गया,
during the
अभी बोल दिया ना वो तो.
नहीं बट मतलब फ्यूचर के लिए भी फ्यूचर लिटिगेशंस फ्यूचर
That is
obligations.
one point, na?
Yes.
That is covered in the one point. It
Yes.
has made sufficient provision.
Yes. And then preservation of sufficient provision for preservation of records.
Now, somebody asked me this question, when the company will be dissolved, so
I
when
asked
they will preserve these records?
That I asked. Yes.
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 But the answer is available in the regulations itself. Because in regulation itself, there is a provision for preservation of records. And what it says? Preservation of records का भी provision है ना? Regulation 41. So regulation 41 will be able to answer your question. What is the regulation 41? I hope now it is visible on your screen. Is it visible?
No.
Visible है ना?
Yes, sir.
So what it says? Who will preserve?
Liquidator shall preserve.
Yes, please read it out.
The liquidator shall preserve electronic copy of all records, physical and electronic, for a minimum period of 8 years, and a physical copy of records for a minimum period of 3 years.
Right. So there, this question is also answered. Now, next question. Whether this declaration and affidavit is one and the same thing, or declaration is something else and affidavit is something else?
Both are different, I think, sir.
Different.
Both are different. Okay. So suppose you have to make a declaration. So how you will make the declaration? And suppose there are 4 directors in a company, each having equal share. So now how many directors will be required to make this declaration?
3.
3, right. And declaration they will make on what? On the letterhead of the company or on plain paper? How they will make this declaration?
On a plain paper.
On a plain paper, okay. And
But
it
it
has
should
to
be verified by affidavit.
Yes. So it has to be supported by an affidavit, and affidavit, there is a format for affidavit that, okay, it has to be on a stamp paper, duly notarized, and all those things.
Yeah.
I know. So now these are the things. This is the first thing. Now second thing, what will they will do? They have made a declaration and it has been supported by affidavit also. Now what is the next thing they will do?
Shareholders resolution.
And whether this
resolution.
declaration, along with this declaration, they will attach some documents also.
Yes, sir. Audited financial statements
Audited financial statements.
and a
Yes.
valuation report
Right.
by registered valuer and disclosure about the pending proceedings.
Right. So these are the 3 things they will be enclosing along with the declaration. Now, next point is, Acha, regarding this declaration, so how you will decide the majority? Majority is to be decided by the number or what? Because it
Yeah,
says
majority is 51%. Number.
Okay. And now this within 4 weeks, what is the next step? Declaration they have made, supported by an affidavit. They have enclosed the things. Now what is the next thing to be done?
Resolution.
A resolution. Okay. So how this resolution is to be passed? Whether any notice is required to be given for this?
Yes, sir. In the case of private limited company.
Okay. And in case of public limited?
Yes, sir. Of course.
Right. So they have to give a notice. Proper notice has to be given. And normally extraordinary general meeting is called for this purpose.
Right.
Because it has to be passed by special majority. And whether this majority in case of a company, suppose this voluntary liquidation is regarding the company. So the what is meant by this special resolution? So special resolution means whether 75% of the number of shareholders or 75% of paid up share capital. What is the meaning?
Paid up share.
Haji?
Paid up share capital.
Right. So it has to be as per the paid up share capital. Okay. Now they have passed this resolution also. Now what is the third thing they will do? So they made a declaration supported by an affidavit and they attached along with the declaration certain documents. Now they passed a special resolution also, or resolution in certain cases. Then what is the next thing they will do? Third step.
Then notify
Creditors meeting. 7
Right.
days, within 7
So
days.
then they will check whether there are any creditors. If there are any creditors, so then creditors representing
to
third in
take
value of the rate of the
Approval the
person.
resolution.
Right. They shall approve
Yes.
the resolution.
Hmm.
So creditors representing 2/3 in value of the corporate person. Next point. Next, what they will do after that? So now they have made a declaration supported by an affidavit. They have passed a special resolution and they have got the approval of the creditors also. So what is the next thing to be done?
Corporate person notified to registrar and board.
So what are the documents they will enclose along with the notification? Definitely there will be covering letter. Along with the covering letter, what are the documents they will attach?
The declaration,
Right?
Resolution.
affidavit,
Right.
Resolution.
Very correct.
and audited balance sheet of 2 years, and valuation
report.
Valuation report. What else?
and approval of the creditor.
Right.
If a creditor is have.
हाँ. और स्पेशल रेजोल्यूशन भूल गए आप?
Yes, a special resolution
25
also.
paid up share capital.
हाँ, वो भी होगा, है ना? Anything else?
Yes, sir.
और भी कुछ होगा इसमें? Whether there is any fees? एक पॉइंट और छूट रहा है आपका. एक हिंट दे देता हूं. There is one point which you are missing. What is that?
The normal resolution.
नहीं, वो तो एक ही बात है. Either that will be a special resolution or normal resolution. But there is one point which you are missing. एक चीज और देनी है आपको. ये लास्ट लाइन कैन यू रीड बिफोर दिस प्रोवाइजो प्रोवाइडेड दैट द कॉर्पोरेट पर्सन ओज एनी डेट. इससे पहले वाले लाइन पढ़िए जरा.
A resolution of the partners contributory as the case may be requiring corporate
नहीं, वो
person.
तो हो ही गया ना. वो
Yes,
नहीं.
sir. Appointing
hint है, last line.
appointing an insolvency professional to
Right.
act.
So the terms and conditions of appointment of this liquidator shall also be enclosed along with his consent. ये भी आपको enclose करना है.
Yes, sir.
Because through this resolution you are appointing him also, है ना? So this thing also has to be notified to the registrar and the board. ठीक है? तो terms and conditions of appointment of the insolvency professional along with a consent letter. ठीक है, अब थोड़ा थोड़ा पता चलना शुरू हो गया. ठीक, now it has been done. Now suppose the liquidator has to be replaced. So how he will be replaced?
In in a
Corporate person has replaced.
shareholders meeting, sir. Shareholders meeting.
Right. Whether by special resolution or ordinary resolution. It has to be by
Special
resolution. Why? Because
Special
whatever are the
yes.
conditions for original appointment, they will be same for replacement also. By
Yes.
who appointed this insolvency professional? Shareholders by way of special resolution only appointed him. So definitely they will
Correct.
be the persons who will replace. ऐसा ही होगा ना? अपॉइंटमेंट के टाइम पे इनिशियली अपॉइंटमेंट किसने किया था?
Yes.
स्पेशल रेजोल्यूशन और ऑर्डिनरी रेजोल्यूशन, एज द केस में बी. सो हियर ऑल्सो सेम वे ही विल बी replaced. Now, whether this insolvency professional has to notify something separately and to whom? Suppose you have been appointed as a voluntary liquidator. Now, the company has already notified the board and the registrar.
Register.
Now, whether you are required to make a separate disclosure and
Yes,
yes, to whom?
to the board.
Yes. Within how many days?
7 days.
Within
7
7
days.
days. Right? So you also have to intimate to the board about such appointment. Now suppose you are a liquidator and you want to appoint some professionals. So whether for appointment of professionals, consent of the corporate person is also required or not?
Yes.
But nothing is written. It says a liquidator may engage professionals to assist him for a reasonable remuneration. The only precaution he has to take is that he should not give them unreasonable remuneration. So far as everything is reasonable, he can justify. So then he is within his powers. But definitely, because the corporate person has to bear all these things, so if there is something unreasonable, then they may take him to task. Otherwise, he has the powers. Public announcement within how many days? Public announcement by liquidator.
30
5
days.
days.
हाँ जी,
5 days.
5 days.
लिखा ना 5 days है ना. Now suppose there are dues of the income tax department. So whether you are required to take NOC from the income tax department, GST, customs,
Corporate person.
what he will do? Or whether public announcement itself is sufficient. You are a liquidator of a company. Now there are dues of the income tax department, GST department, customs department, which are reflected in the books. Now the question is whether you will get in touch with them separately or public announcement itself is sufficient, or whether you are required to take NOC from them. What is the
Public announcement is sufficient.
Yes, actually there is an IBBI circular which says that you need not take separate NOC from these departments, and public announcement itself is deemed to be sufficient compliance. But there is a catch here. The catch here is, suppose the department does not file any claim. Then what will happen? Whether you will ignore their claims, there are liabilities which are existing in the books. You are the liquidator. Suppose there is a
It
liability.
is your duty, sir. It is your duty to take the liability as per books.
So that is why you should
cannot
get in
ignore.
touch with them, and you can notify them that okay, this company is in voluntary liquidation, and public announcement has already been made, although it might have missed by you, and you have not made your claim. So please lodge your claim so that it could be processed accordingly. So nobody
Yes.
stops him from doing all these things. Rather, suppose he ignores their claims and he distributes the amount to stakeholders, to the shareholders, then he may be in trouble.
He may be in
Because
trouble.
it says the directors have made the declaration. What is the declaration?
Sufficient provision.
Yes,
Sufficient provision has been made.
So directors may be held personally liable. If tomorrow a liability comes, then these directors may be held personally liable. It clearly says. So they have to disclose about the pending proceedings or assessments. Another thing, they will list each debt also. This is also important. What it says, the declaration shall list each debt of the corporate debtor. So in the declaration, they will enclose a list of each debt of the corporate person as on that date, and state that the corporate person will be able to pay all its debts in full from the proceeds of assets to be sold in liquidation. So in the declaration, they will list each debt. That is also important. Okay. Suppose there are dues of the directors of the company. Okay. Suppose meeting fees is there or director's remuneration is there, and some assets of the company were, say, issued to them. Although as per books of the company, they are the assets of the company, but they have been issued or they have been used by the directors, like laptops, suppose. So whether in exchange of their dues, you can sell them those laptops? If yes, whether any permission is required from any authority? This is the question. And this question came in the examination also. Directors' dues are there, and now the liquidator wants to settle this claim by giving them laptops, which are already with them. So whether he can do so?
Yes, sir.
And whether any approval is required for this?
No approvals.
Regulation 35. 35.
Yeah, with the approval of the corporate person.
Now, what is the meaning of approval of corporate person? Because corporate person is represented by whom? He is represented by shareholders. So who will ultimately approve? Shareholders will approve.
Yes.
The only question could be regarding the special majority or ordinary majority. That could be the only question. But approval means, naturally, Simple majority at least.
Yes.
Sir,
Now suppose there was a person. Yes, please.
in case of two director or two shareholders, so what is the majority?
Both.
Both. Okay.
Both. Now
And
suppose
one of against and one of favor.
then voluntary liquidation not possible.
Okay.
There was a claimant who had filed the claim, but he did not turn up because he died. Now his son wants to claim the amount. Dissolution has not yet taken place. To whom he will approach? Everything is over.
IBPA.
No,
IBPA.
please remember that dissolution has not yet taken place.
Oh, right, sir. Understood.
So then, point number 7. I think it is visible on your screen. My screen is visible?
Yes.
Point number
Yes,
7.
sir.
What it says? Is it readable?
Yes.
Yes, sir.
Readable.
So please read this. What it says?
Prior to dissolution of the corporate person, a stakeholder who claims to be entitled to any amount deposited into the corporate voluntary liquidation account may apply to the liquidator in Form I for withdrawal of the amount.
So he will apply to the liquidator. But suppose dissolution has taken place
Yeah,
then?
IBBI.
Yes. Point number 70. After dissolution. Form is same.
After
Why?
dissolution of the corporate person, yes. 70 says after dissolution of the corporate person, stakeholder who claims to be entitled to any amount deposited to the corporate voluntary may apply to the board in Form I. Right? The form is same form for an order for withdrawal of the amount. Is it correct, sir? The form is same?
Yes, form is same.
Yeah.
Okay, now let us do some case studies on this. Voluntary liquidation.
Yes.
So I hope my screen is visible. Is it visible?
Visible, sir. Visible.
Yes. So please read this case study, what it says.
Happy New Year Limited wants to liquidate itself voluntarily and has approached you for guidance in this regard. Balance sheet of Happy New Year Limited is as under. In view of this, please answer the following questions. Balance sheet as on 31st March 2022. These are all rupees in lakhs. Okay, you have a share capital, debenture, current liabilities, provisions, totally 180 lakhs, which is a source, liabilities, fixed assets, investments, cash balance accumulated. This is how 180.
So based on this balance sheet, please tell me whether creditor's approval will be required or not in this situation. You are having a balance sheet.
Required,
It will be required, sir,
Required, sir.
because
Yes, sir.
assets will not
Required,
be
sir.
sufficient.
Required.
Debentures.
Okay. Debenture, apart from debentures, any other thing?
Current liabilities.
Current
Right.
liability.
Provisions,
Okay.
everything.
Whether any valuation will be required?
Yes, sir.
Yes.
Yes.
Fixed assets, investment.
Right.
Your financial assets also there.
No, regarding cash and bank balance, no valuation is required.
Investments.
Investments.
Yes, investments, sir. Fixed assets, right. What are the formalities before the company appoints you as a liquidator? Out of this, what is the correct option? So within 4 weeks, you know, within
Yes,
4
correct.
weeks, something is to be done within 4 weeks of the declaration.
Yes, resolution to be passed, sir.
Okay. Whether this declaration is declaration or special declaration.
Special declaration,
Normal declaration.
not ordinary.
Normal.
It is
Ordinary.
declaration only, nothing special.
Okay.
Word used is declaration from majority. Now, second point. So, first thing, declaration or special declaration? Declaration. Then whether majority or special majority
Majority.
regarding this special resolution.
Special resolution is always from the majority. No. Special resolution from 75% of the share capital. Paid up share capital.
So, first of all, now let us see it item by item. First of all, within 4 weeks of the declaration from majority of the designated partners or directors, special resolution to be passed by the partners or contributors in a general meeting requiring the company to be liquidated voluntarily. So whether this statement is correct?
Sir.
This statement is correct.
Yes, sir.
Right. So just note a few things. Number one, it has to be declaration. Second, then majority of designated partners or directors. In case of pre-pack, it is majority of partners in case of LLP. But here it is majority of designated partners. Then special resolution to be passed by the partners or contributors in a general meeting. Just a basic question. This question came in the exam also. For special resolution, number of shareholders present in the meeting has to be considered or their shareholding percentage. Suppose there are 10 shareholders in a private limited company, out of which A is holding 20%, B is holding 40%, C, D and rest of the 8 are holding 5% each. Now in meeting, only A, B, C and D are present. So whether 4 persons will be considered or their shareholding percentage?
Shareholding percentage.
Right. So it is the number of partners for LLP, but in case of LLP, there is no such percentage. For in case of LLP, it is the number of partners and percentage of voting share for company. Okay. Number
Present
of
in the meeting.
Have
Present
you-
in the meeting. Present in the meeting. Sorry. Sir, present in the meeting, yeah, whole capital of the paid up capital.
Whole capital.
If not sufficient shareholders are present, then
then the meeting, then the quorum will not. First
Not
of all,
be.
they will see whether quorum is present or not.
Okay.
Second is then requisite majority, they will again call the meeting. Meeting shall
Okay.
stand adjourned.
Okay.
So it is the number of partners for LLP and percentage of voting share for company. Number of members, partners present is important for quorum. If we see MGT 14, so form MGT 14 itself says both things are required. Number of shareholders and voting. Number of shareholders, why it is important? For the purpose of quorum. And this percentage is required for special resolution. So registrar referred to involuntary liquidation process because they are saying you will notify the registrar and the board. So registrar कौन सा है ये? NCLT का registrar. In NCLT also there is a registrar.
MCA.
Registrar of
MCA.
MC. For the following documents, which is the appropriate authority? Registrar or adjudicating authority or both? Suppose you pass this resolution passed by partners or contributors. So to whom you will notify this thing?
Registrar
Registrar and board, sir.
Registrar and
Registrar and board.
NCLT.
Huh?
Registrar and board.
Yes. Liquidator feels that liquidation is being done to defraud a person. Then to whom you will notify?
AA, appellate authority.
Yes.
Because it's not in compliance.
Right. So you want to disclose the pecuniary interest by a liquidator with the CD or stakeholders. So it has to be informed to the registrar and the board. Final report of
Board.
liquidation.
All three parties.
All three. Creditor filing an appeal against decision of liquidator within 14 days of the receipt
Again,
of such
adjudicating authority. Appeal.
liquidator feels that the corporate person shall not be able to pay its debts in full.
Adjudicating authority.
Again, AA1.
Now, so there are 4 forms also. VL1, VL2, VL3, VL4. So are you aware about those forms? VL1, VL2,
No, sir.
VL3, VL4. And with whom you will file these
Kindly
forms?
comment.
कल पढ़ा था हमने.
हाँ. With whom you will file these forms? ये फॉर्म फाइल किसके पास करने हैं आपको?
IBBI, sir, IBBI.
Right. So it says on an electronic platform of the board, and there are timelines for that. ठीक. Contributory means besides a member of the company, partner of LLP, any other person liable to contribute towards the assets of the corporate person. Whether holder of fully paid up shares is a contributory or not. There is a holder
sir.
of fully paid up shares. So
Not
whether he can be
contributory because
considered as
Yes.
his share is fully paid up.
Yes.
Yes, sir.
He is still called as a contributor.
Right.
Yes.
The answer you will find in section 2, subsection 26. So we can go to section 2, subsection 26 of the Companies Act for this purpose. Section 2, subsection 26. Contributory means a person liable to contribute towards the assets of the company in the event of its being wound up. Explanation. For the purposes of this clause, it is hereby clarified that a person holding fully paid up shares in a company shall be considered as a contributory, but shall have no liabilities of a contributory under the Act whilst retaining rights of such a contributory.
Okay.
ठीक है जी. Sure.
Yes, sir.
Okay. Holder of partly paid up shares.
Yes,
Liable to
contributory.
pay.
Partly
Contributory and liable to pay.
Legal representative of a deceased member.
Yes.
Official assignee or receiver of a contributory.
Yes. Yes, sir.
Liquidator of a company. Liquidator contributory है नहीं है?
He is
The
not a
liquidator तो sir.
contributor.
हाँ,
He is
भाई, he
not
is
a
an independent
contributor.
professional, है ना? वो क्यों contribute करेगा?
Yeah.
A liquidator is required to deposit the amount of unclaimed dividends, if any, and undistributed proceeds, if any, in a liquidation process, along with any income earned thereon till the date of deposit into the following account. कौन सा account है?
Corporate voluntary liquidation account.
हाँ, तो इसका नाम है corporate voluntary liquidation account. Which of the following is not included in the definition of stakeholders? गवर्नमेंट अथॉरिटी स्टेक होल्डर है नहीं है?
No.
गवर्नमेंट अथॉरिटी स्टेक होल्डर नहीं है?
Yes,
No.
sir. It is stakeholder only.
Stakeholder, what is stakeholder? Stakeholder means anyone who is entitled to distribution of proceeds under section 53. तो गवर्नमेंट अथॉरिटीज को तो मिलता है ना प्रसाद.
Sir, liquidator. Yeah.
Sir, all three are stakeholders: government authority, resolution professional,
None of
and
the above,
liquidator.
sir.
Specify the situations under which instead of a resolution passed by special majority, a resolution of the partners or contributors is sufficient. So instead of special resolution, ordinary resolution is sufficient.
Okay.
What are the situations? Corporate person needs to be liquidated due to expiry of its period of duration. Whether in this case, ordinary resolution is sufficient?
No, sir.
Suppose it is written that
Yes, sir, it is yes.
yes,
Ordinary resolution is good if you have to liquidate due to the efflux of time or fixed
Right.
period, expiry of your period.
right. And second point, occurrence of any event requiring
That
division-
is also true. That is also true. Ordinary resolution only required.
Okay. The corporate person shall notify the dash and the dash about the resolution to liquidate the corporate person within 7 days of such resolution or the subsequent approval by the creditors as the case may be.
Registrar and board.
Registrar and board. Okay. Can the following options be availed in case of voluntary liquidation?
सर पिछले क्वेश्चन में आईबीबीआई भी लिख रहा है, बोर्ड भी लिख रहा है, तो कंफ्यूज हो सकता है क्या सर?
भाई अगर जो लिखा जो एक्ट में लिखा वही पढ़ना पड़ेगा आपको. रजिस्ट्रार एंड बोर्ड लिखा हुआ तो वही लिखना पड़ेगा. अगर ये दोनों ऑप्शन आ गई तो फिर रजिस्ट्रार एंड बोर्ड वाले को ही क्लिक करना पड़ेगा.
In the act, it is mentioned board only, not IBBI, right, sir?
कैन दी वैसे ऐसा देगा नहीं, बट हमने जानबूझ के ऐसा दिया. अगर ऐसा दोनों दे देगा तो फिर बोर्ड आपको टिक करना. कैन दी फॉलोइंग ऑप्शंस बी अवेल्ड इन केस ऑफ वॉलंटरी लिक्विडेशन? कॉम्प्रोमाइज, अरेंजमेंट और अमेलगमेशन हो सकता है क्या इन केस ऑफ
No.
वॉलंटरी लिक्विडेशन?
नहीं सर.
No.
नहीं. कैरिंग ऑन द बिजनेस एज ए गोइंग कंसर्न
Not
No.
possible.
No.
है ना. तो इसमें these options cannot be availed. Is the liquidator required to intimate the board about appointment as liquidator
Yes.
Yes.
Within
Yes.
7 days.
Within 7
days
days.
of his appointment? Right. An insolvency professional was an auditor of the CD 2 years ago. ठीक है. There is an insolvency. There is a chartered accountant. He was an auditor of the CD 2 years ago. Now he has become an insolvency professional. But he did not charge any audit fee.
No.
Can he be appointed as a liquidator?
Yes.
No, sir.
Yes, sir. Because his 10% criteria.
No. 10% criteria is for legal or consulting firm only. Please read this regulation number. It says he has been an auditor during the past 5 years.
Okay.
So simply the fact of having been an auditor is sufficient to disqualify him.
Okay. Okay. Good.
Yes, sir. Yes, sir.
So I forgot that 5 years.
Yes, whether he has taken fees or not, that is irrelevant.
Yes. Mhm. Regulation 6(1) C(1). Can the liquidator admit the claims of a workman or an employee on the basis of books of account in case such workman or employee has not made a claim.
It is obligatory for liquidators.
Yes. So, because there is regulation number 18, sub regulation 4, sorry. So 18.4 says, shall. The liquidator shall admit the claim. So it is obligate.
एक्चुअली वो लिस्ट प्रोवाइड करता है सीडी, राइट? ये सब
हाँ,
क्लेमेंट है।
बिल्कुल बिल्कुल. Who will make the public announcement? Public announcement किसको करना है? लिक्विडेटर को करना है.
Liquidate.
अच्छा, suppose public announcement was not made properly. Can this public announcement be made again?
Yes.
Public announcement में क्या क्या होना चाहिए? What are the contents of this public announcement?
Submission of claims.
Right. So there are
Last
certain
rate.
important fields. Form A is there. So we have to go as per the Form A, contents of Form A. Whether there is any scheme of withdrawal also, एक कोई provision है withdrawal. Suppose voluntary liquidation is commenced. Now you want to withdraw. Can you withdraw? Like in case of CIRP, there is a provision for withdrawal. अभी इस केस में क्या होगा? Voluntary liquidation में. Voluntary liquidation is started. Now you want to withdraw. Can you
Sir,
withdraw?
before the order of the A, one can withdraw.
Okay. So actually there is no specific provision in the voluntary liquidation, but naturally वो जो process किया था at the time of start, so same process has to be followed for withdrawal also. वही आपको special majority लेना पड़ेगा shareholder से, तभी तो withdraw कर पाएंगे ना. And next question will come, who can sanction this withdrawal? So naturally it has to be with the special majority, है ना? तभी तो withdraw कर पाएंगे ना. Although there is no such specific provision. What is the date of commencement of voluntary liquidation?
Passing of resolutions, sir. Shareholder resolution.
Yeah, nothing mentioned. Yeah.
Ah. Who will appoint and replace the liquidator?
Corporate person that is a shareholder agreement.
सर मैं एक मेरा क्वेश्चन पहला ये है, जब स्टार्टिंग में हमने पूछा था कि इफ द कॉर्पोरेट पर्सन कम्स टू यू टू फॉर गाइडेंस,
Right.
we are not appointed as a liquidator as yet, but he comes to us as a for
As a
for guidance
professional, yes.
as a professional. तो सर फिर हमारा कंपनी के साथ तो स्टार्ट हो गया रिलेशनशिप बिफोर बिकमिंग लिक्विडेटर. सो कैन वी बिकम लिक्विडेटर बिकॉज एक प्रोफेशनल ट्रांजेक्शन हमारे बीच में हो गया है बिफोर बिकमिंग लिक्विडेटर.
नहीं, वो तो उस प्रोफेशनल कंसल्टिंग फर्म का 10% वाला क्राइटेरिया है ना, उसमें तो
ओके
10% थोड़ी ले लिया होगा आपने उतनी जल्दी.
हाँ पर बट वो 10% अगर ब्रीच करता है तो फिर नहीं कर पाएंगे वो, तो फिर मतलब रिलेशनशिप स्टार्ट हो गया है इसलिए.
Yes.
हाँ, लीगल और कंसल्टिंग फर्म आ गया ना, तो उसमें
ओके
क्या है,
ओके
10% वाला क्राइटेरिया में देखना पड़ेगा फिर.
ओके.
हाँ, ऐसे तो सलाह तो ले ही सकते हैं ना, कोई दिक्कत नहीं. ये हो गया. अच्छा, दिस क्वेश्चन ऑल्सो दे आर वेरी फ्रीक्वेंटली आस्किंग, विड्रॉल प्रोविजन. Withdrawal में they may give different options, so depending on the options you have to tick. Suppose they give you the option there is no specific provision for withdrawal, so then you will have to tick that option. Suppose there is no such thing, so then the procedure which we followed at the time of commencement of voluntary liquidation, we will have to follow the same process. Preliminary report within how many days and to whom? Preliminary report.
$45.
किसको देना है? To whom
To
you have
the
to give?
corporate person, sir. To the corporate person.
No, corporate person will inform, no?
हाँ, to the corporate. Periodicity of preparation of status report under voluntary liquidation. पहले
Annual.
annual था, अभी एनुअल भी हटा दिया वैसे इन्होंने. पब्लिक अनाउंसमेंट आपको करना है कितने दिन में?
5 days.
Form A
Form
of
A,
Schedule
Schedule
1.
1, yeah.
In case the corporate person has initiated the voluntary liquidation proceedings maliciously, are there any penal provisions under IBC for such situation?
Yeah, Chapter 7 will apply, sir.
Chapter 7 will apply. ठीक है, तो section 65 subsection 2 talks of this situation. So in this case there could be fine 1 lakh to 1 crore rupees. In case the promoter of the company has gifted residual portion of the land to a relative of his spouse and the liquidator knew about the deal, so what is the possible cause of action in case this transaction is brought to the notice of the AA by the jurisdictional tax authorities? So the answer is given in section 47, because section 35 to 53 they apply to voluntary liquidation also. ठीक है, तो 47 टू बी से हिट हो जाएगा. So A shall make an order restoring the position as it existed, as if the transaction had not been entered into, and thereby protect the interest of tax authorities.
Undervalue transaction.
In case of an attempt of concealment of any property transaction, what punishment can be awarded to the promoters? This is given in section 68. So it says, with imprisonment for a term which shall not be less than 3 years, but which may extend to 5 years, or with fine 1 lakh to 1 crore rupees, or both. So this for falsification of books also, section 71, imprisonment 3 to 5 years, fine 1 lakh to 1 crore, or both. The company had 20 crore rupees as uncalled capital, which it called up now. The company has already credited a charge on such uncalled capital and raised rupees 10 crore against it from M&M Private Limited. Okay? In view of this, please answer the following. In case a shareholder does not contribute towards the uncalled capital, whether he shall be entitled for distribution as per section 53?
No.
No. So it says, if you do not contribute towards the uncalled capital, then you will not be entitled for distribution also. Within how many days the contributors are required to make this payment? कितने दिन के अंदर आपको पेमेंट करना है?
15 days from the date of notice, regulation 33.
हाँ, तो रेगुलेशन 33 क्या बोलता है? कितने दिन के अंदर करना है आपको?
15 days from the date of receipt of notice.
थर्टी थ्री वाला वैसे इन्होंने वॉलंटरी लिक्विडेशन से हटा दिया ये. अब पता नहीं क्यों हटा दिया इन्होंने. 33 वाला डिलीट कर दिया.
ओके.
28 जनवरी 25 से कर दिया. रेगुलेशन 33 हटा ही दिया इन्होंने. ये ध्यान में रखना आपने. चलो कोई बात नहीं. सपोज चलो फिर तो ये क्वेश्चन ही हटा देंगे हम इसमें से. फिर हम ये क्वेश्चन रखेंगे ही क्यों इसमें, है ना? ये क्वेश्चन ही हम डिलीट कर देते हैं इसमें से. भाई रेगुलेशन 33 इट हैज बीन डिलीटेड नाउ.
नहीं सर, वो डेट डाल देते हैं ना जहां से ये एप्लीकेबल नहीं है.
हाँ,
दैट विल बी बेटर.
हाँ, ये ओमिटेड हो गया.
यस, ओमिटेड
व्हाइल
फ्रॉम विच डेट?
नोटिफिकेशन डेटेड 28 जनवरी.
28 जनवरी 2025.
हाँ, omitted void notification dated 28 January 2001.
There is no time limit now.
हाँ, चलिए.
Sir, there is no time limit.
नहीं, रेगुलेशन इटसेल्फ हैज बीन ओमिटेड. पूरा का पूरा रेगुलेशन ही उड़ा दिया इन्होंने. रेगुलेशन 33 omitted.
So, okay, sir, what is the effect now? By
Effect is
omitting
they are
that.
not envisaging any such thing that he will call up the capital and all those things. In case of voluntary liquidation.
Other provision will apply now.
Yes. Is it necessary to have a stakeholders committee in case of voluntary liquidation? Stakeholders committee.
No. No.
यस नहीं.
No.
Regulation 12 देख लीजिए क्या बोलता है. Regulation 12 says the stakeholders consulted under section 35(2) shall extend all assistance and cooperation. The liquidator shall maintain the particulars of any consultation with the stakeholders. Actually, in case of voluntary liquidation, there is no concept of stakeholders consultation committee.
कमिटी नहीं है लेकिन
कमेटी नहीं
कंसल्टेशन
है.
ओनली.
स्टेकहोल्डर्स जो होंगे ना उनके साथ कंसल्टेशन कर सकता है एंड ही हैज टू मेंटेन द रिकॉर्ड्स ऑफ कंसल्टेशन. बस इतना ही है ना.
Correct.
In case the liquidation process continues for a period of more than 12 months नहीं, अभी ये भी चेंज कर दिया, for more than 270 days, for more than 270/90 days, because there are two provisions. So what are the steps to be taken by the liquidator? Suppose it continues, then what he will do?
He will call the contributories meeting.
Right. So meeting of contributors has to be called within how much period? Period भी होगा ना?
15 days.
Within 15 days, right. And he shall present the status report. Yes, annual भी हटा दिया इन्होंने word. Now they have removed the word annual. So now they are saying status report. Audited accounts of receipts and payments. Details of assets sold, filing of avoidance transactions. So what is the time limit within which this application has to be? Now suppose this voluntary liquidation started, everything is complete now. Now the liquidator wants to make an application to the adjudicating authority for dissolution. So whether there is any time limit which is specified? We can refer to section 59, subsection 7 for this.
No time limit. As soon as possible.
So whenever there is nothing is mentioned, it says the liquidator shall make an application for the dissolution. So definitely, when nothing is mentioned, then as soon as possible. You cannot say that, okay, I will file after 6 months or 1 year. No, as soon as possible. Take. And suppose this option is not given as soon as possible. So then you can click this no such time limit.
No such limit.
Depending upon the options which are available with you. The values as assessed by registered valuer are as under investments and fixed assets. Now, another important question, whether you will appoint one valuer in case of voluntary liquidation or two valuers.
One valuer.
Two valuers, sir. Because for each class, if there are different class of assets.
No, for each class I'm asking.
One valuer.
Actually, where it is written? Is it written anywhere?
38
It is
one.
silent. It is
Huh?
silent.
Regulation 38 1B.
नहीं, रेगुलेशन 38(1)(b) में क्या लिखा हुआ? 38(1)(b) क्या बोलता है?
That it's regulation 3 only, sir. Report of valuation of the assets of corporate.
वो तो that is वो something else है. वो तो छोड़ो ना. Point here is, my question is whether he will appoint one valuer or two valuer in case of voluntary liquidation. Actually, you will find this answer in section 35 to 53. वहां पर है ना section 35 to 53 में.
It will apply to
इसमें
us.
तो 2 है, सर.
तो बस उसमें 2 है, तो यहाँ पर भी 2 है ना. वहां कौन सा सेक्शन है? 35 to 53 में. It is given in powers of liquidate 35(1)(c). 35(1)(c) क्या बोलता है? To evaluate the assets and property of the corporate debtor in the manner as may be specified by the board and prepare a report. तो specified by the board में regulations पे चला जाएगा, and regulations will take you to two valuers in case of liquidation. तो यहां पर भी दो ही होना चाहिए. The statutory auditor, you can write in the group if there is any variation, if you do not agree. आपको लगता है, किसी को लगता है एक होना चाहिए?
नो सर.
The statutory auditor qualified the audit report. ऑडिटर ने स्टैट्यूट जो ऑडिट रिपोर्ट थी उसको क्वालिफाई कर दिया कि भाई फेमा का वायलेशन है. ठीक है. एंड लाइबिलिटी ऑन अकाउंट ऑफ, उसने लिखा स्टैट्यूटरी ऑडिटर ने कि लाइबिलिटी ऑन अकाउंट ऑफ वायलेशन में कम टू द ट्यून ऑफ 50 lakhs. ठीक है. आरबीआई को कोई नोटिस नहीं मिला है. तो आपको क्या लगता है कि वेदर द कंपनी इज सॉल्वेंट एंड फुली एबल टू पे इट्स डेट्स इन फुल? आप एक बार ये वाला रेगुलेशन देख लीजिए. ये रेगुलेशन क्या बोलता है भाई? अभी तो क्या हो गया, अभी इन्होंने दे हैव मेड अ चेंज इन द रेगुलेशंस. अभी कर दिया प्रोविजन, है ना. इन डिक्लेरेशन ऑल्सो दे हैव मेड दिस चेंज. यहां पर तो ये देना पड़ेगा इसको. अभी प्रोविजन करना है नहीं करना है वो दे हैव टू सी. अगर प्रोविजन नहीं करना है, सपोज टुमारो लायबिलिटी कम्स, देन डायरेक्टर्स विल बी हेल्ड पर्सनली रिस्पॉन्सिबल. 31(b)(3), no litigation is pending against the corporate person or sufficient provision has been made to meet the obligations arising from any pending litigation. So either they will confirm that there is no litigation or they will make sufficient provision. They may ask the RBI also on their own for compounding. ठीक है. अच्छा, शेयर होल्डर्स को भी फॉर्म भरना है क्या या नहीं भरना है? ये बहुत सारे लोगों को क्वेश्चन होता है. आपको क्या लगता है, भरना चाहिए नहीं? अजय जी क्या लगता है आपको?
सर नहीं
सर भरना तो चाहिए क्योंकि उनका तो अमाउंट
सर,
वापस
का कुछ
डिपॉजिट
क्लेम रहेगा तो सर,
Yeah, shareholder can file a claim.
भाई
क्लेम तो रहेगा ही ना.
19(2)(b) का 2 देख लीजिए क्या बोलता है. डॉक्यूमेंट्री और इलेक्ट्रॉनिक एविडेंस ऑफ हिज शेयर होल्डिंग. तो इसका जरूरत क्यों पड़ेगा अगर डॉक्यूमेंट और एविडेंस ऑफ हिज शेयर होल्डिंग? देयर माइट बी डिविडेंड. डिविडेंड भी पेएबल हो सकता है ना.
राइट.
वो तो क्लेम करेगा ना अपना.
राइट.
अगर मान लीजिए सम डिविडेंड इज पेएबल तो क्लेम नहीं करेगा वो.
बिल्कुल.
इट इज सेइंग क्लेम बाय अदर स्टेक होल्डर्स. और एविडेंस में क्या लगा रहा है? डॉक्यूमेंट्री और इलेक्ट्रॉनिक एविडेंस ऑफ हिज शेयर होल्डिंग.
एक्सेस फंड जो रहेगा वो भी तो बटेगा सर शेयर होल्डर्स में. जो सरप्लस फंड्स रहेगा वो भी तो शेयर
सरप्लस.
होल्डर्स में बटेगा.
सरप्लस तो बटेगा. सरप्लस
Basically
के
तो
अलावा कोई एग्जिस्टिंग लाइबिलिटी भी हो सकती है बुक्स में.
यस.
In case, perhaps in case of surplus, no claim is need to be filed by the shareholders.
नहीं वो ठीक है.
That
But
is duty of the liquidator.
नहीं वो ठीक. मेरा क्वेश्चन ये है कि सपोज सम डिविडेंड इज पेएबल तो क्लेम फाइल करेगा नहीं करेगा वो?
Yes.
है ना.
Yes.
Whether set off is available? The answer is yes, set off is available. Partner of an LLP is a contributory. Correct. Member of
Yes.
company is contributory. Yes. Liquidator of a company is contributory. No.
Yes.
Acha, regarding professional, a professional in order to be independent should not have been an auditor of the corporate person at any time during the 5 years preceding the liquidation commencement date. तो ये जो 5 years है, ये कैलेंडर ईयर है, फाइनेंशियल ईयर है, क्या है ये?
फाइनेंशियल ईयर.
हाँ.
Financial year perhaps.
देखिए ऐसा है, ये ना तो कैलेंडर ईयर है ना ये फाइनेंशियल ईयर है.
Condition.
जनरली
आपको
अकाउंट्स आर प्रिपेयर्ड.
I
डेट
फाइनेंशियल
वाइज
सर.
बैक डेटिंग पे जाना है आपको. समझ रहे हैं आप?
सर जनरली फाइनेंशियल्स आर प्रिपेयर्ड
ले लो कोई.
फॉर
तो
फाइनेंशियल
क्या
ईयर
होगा?
बेसिस.
let us read regulation number 11. What regulation 11 says?
सर इसमें डेट्स है, डू 5 years preceding the liquidation commencement
बस
date,
आपको
date।
लिक्विडेशन कमेंसमेंट डेट से 5 साल पीछे चले जाना है। ना
डे टू डेट
कैलेंडर
है।
ईयर देखना है, ना फाइनेंशियल ईयर देखना है आपको। सपोज यू वांट टू बी अपॉइंटेड एज ऑफ टुडे, ठीक है, आप 10 जून 2025 को दे वांट टू अपॉइंट यू एज ए प्रोफेशनल, तो 5 साल बैक ये चले जाएंगे यहां से 10 जून से, फ्रॉम करंट डेट। वो आपको देखेंगे कि भाई आप जो है कब तक नहीं थे, 11 जून 2019 20 तक ले लेंगे बस आप, उससे पहले अगर आप थे तो ठीक है। तो इसमें ऑप्शन भी तीसरा भी कर देना पड़ेगा हमारे को, तो तीसरा ऑप्शन हो जाएगा हमारा डेट टू डेट। आपको डेट टू डेट देखना पड़ेगा, ना फाइनेंशियल ईयर है ना कैलेंडर ईयर, कुछ भी नहीं है।
करेक्ट आंसर विल बी सी।
आंसर सी हो जाएगा, हाँ और क्या। अच्छा, सपोज द कंपनी इज डिसॉल्व्ड, और डिसॉल्व हो गई कंपनी, नेम वाज आल्सो स्ट्रक ऑफ, लेटर सम इनकम टैक्स डिपार्टमेंट ड्यूज केम, ठीक है। देयर वर टू डायरेक्टर्स इन द कंपनी, वन ऑफ द डायरेक्टर्स हैज डाइड, इन व्यू ऑफ द अबव व्हिच ऑफ द फॉलोइंग स्टेटमेंट्स इज इनकरेक्ट। पहला क्या होगा इसमें?
नो।
ऑप्शन छोड़ दीजिए, ऑप्शन के बिना आंसर कीजिए, क्या होगा, क्या होगा इन दिस सिचुएशन, व्हाट विल हैपन?
The living director has
Understood
to
the question?
pay, the living director has to pay 15 lakhs.
है
The living director is liable only to the extent of share capital subscribed by him. The living director is liable only to the extent of share capital subscribed by him, provided no fraud is established. Sir, ABC, all three right, sir.
Which of the following registers is not required to be maintained by
सर
the
कंट्रीब्यूटर्स के
voluntary?
लीगल हेयर्स भी तो लाइबल है ना, जैसे जो डाइड हो गए उनके लीगल हेयर्स।
भाई लीगल एयर अगर उसके पास कोई प्रॉपर्टी इनहेरिट हुई है तो होगा, अदरवाइज नहीं होगा।
हाँ मतलब लिविंग डायरेक्टर प्लस लीगल हेयर्स भी हो सकता है ना।
हाँ हो सकता,
जी
टू द एक्सटेंट ऑफ द प्रॉपर्टी इनहेरिटेड बाय द,
राइट राइट।
which of the following registers is not required
Sir,
to be,
after stock of name of the company, can it be reinstated on the
yes,
direction of the
within a
government?
period of 20 years,
Okay.
and in many cases company name is restored. So which of the following registers is not required to be maintained by the voluntary liquidator? कौन सा नहीं रखना है?
Tenant register, fees register, reserves.
फी रजिस्टर रखना है कि नहीं रखना है? आंसर को छोड़ दीजिए, आंसर गलत भी हो सकता
Liability register, not
है।
required.
फीस रजिस्टर रखना, टेनेंट रजिस्टर रखना,
Correct. That all ABC you have to maintain, sir. D
Bank
need
limit.
not be maintained because it's liquidated already.
In case provision is made for any liability which might occur, what shall be the treatment? By you in balance sheet, in your balance sheet, some provision is there. So what you will do with that provision? वो प्रोविजन का आप क्या करोगे? But you will reverse that provision and book the actual liability if any. है ना?
Right.
Whether format of affidavit or declaration by majority of directors has been specified. कोई फॉर्मेट दे रखा है क्या?
No.
This case study also you can see. This case study came in the exam.
Oh.
There are three brothers, Om, Jay and Jagdish. Om and Jagdish are having rivalry with each other. बिल्कुल उल्टा चलते हैं, जो ओम बोलेगा यस, जगदीश बोलेगा नो. ठीक है. They have a private limited company where each one holds equal share. All these years, the company was performing well. However, in the last 1 year, due to rivalry, the company booked a loss of 76 lakhs. As per the brothers, they have been repaying the bank loan regularly and no default up to now, except to the CBDT where only 2 months TDS amount is owed. Okay? One of the friends of the three brothers, Mr. Amit, has been approached by the brothers to advise on how to close the company. What option you will suggest? You have understood the question first? Pehle first try to understand the question. There are three brothers. They are the only shareholders in the company. They are all having equal share. 1/3, 1/3, 1/3. But two are having rivalry. Okay? That means two are on one side, one is on another side. No default also, except TDS dues for 2 months. Now they approach Mr. Amit. So what options Amit can suggest as a professional? Whether this company can go in for CIRP?
Yes.
Yes, कैसे?
There should be
But
default of 2
default नहीं है पर हाँ
Default तो है नहीं.
Voluntary liquidation, sir.
voluntary liquidation पर है.
Voluntary liquidation.
हाँ, फास्ट ट्रैक में जा सकते हैं क्या?
No need for fast track.
Whether it can go in for fast track?
सर उसमें भी डिफॉल्ट क्लॉज तो है ही, डिफॉल्ट होना
हाँ.
चाहिए.
डिफॉल्ट तो 1
Three,
करोड़
sir.
ही है उसमें भी.
ये 2 month TDS जो है सर, इसका क्या
Amount is not specified.
अमाउंट ज्यादा नहीं है. अमाउंट 2 months का TDS अमाउंट ज्यादा नहीं.
बट डिफॉल्ट तो है ये.
तो डिफॉल्ट होने से क्या होगा? डिफॉल्ट होने से थोड़ी CIRP पे चली जाएगी.
नहीं, बट ये वॉलेंटरी लिक्विडेशन में तो डिफॉल्ट की वजह से नहीं जा सकते ना, डिफॉल्ट नहीं होना चाहिए.
नहीं, ऐसा है ना. देखिए, देयर इज अ डिफरेंस बिटवीन डिफॉल्ट एंड पेंडिंग लायबिलिटी. अभी क्या लिखा है? ओनली 2 months TDS अमाउंट इज ओड. अभी कोई ऐसा नहीं है. डिफॉल्ट तो नहीं हो गया ना. देखिए, देयर इज अ डिफरेंस बिटवीन लायबिलिटी एंड डिफॉल्ट. ये भी समझिए. एवरी लायबिलिटी इज नॉट अ डिफॉल्ट. जो भी
Company is able to pay it.
yes, if the company is able to pay, then there is no such issue. So every liability is not a default. है ना? And remaining questions were there from voluntary liquidation. So what will be the challenge in the option suggested by Mr. Amit? Now suppose Amit suggests that okay, you go in for voluntary liquidation.
Yes, then वो स्पेशल मेजॉरिटी चाहिए सर.
हाँ, तो स्पेशल मेजोरिटी तो होगा नहीं,
नहीं.
है ना? वो जो one of the brothers है holding 33%, he may prove a stumbling block, है ना? He may not be in favor of the resolution. तो क्या होगा? 67% से resolution, तो resolution will fail,
Right.
है ना? Regarding this dues of CBDT, तो voluntary liquidation is possible,
Not
ऐसे
possible.
दिक्कत, है ना? Because it's a liability only and they will make provision or they will pay.
Right.
A company is facing proceedings under section 138 of the Negotiable Instruments Act for check bouncing case. Can it go in for voluntary liquidation? इनका 138 का केस चल रहा है चेक बाउंसिंग का. तो क्या ये voluntary
If
liquidation
company
में
is
जा
able
सकते?
to pay it.
हाँ.
No.
In case they can prove that okay, they, भाई देखो होता क्या, 138 केस होता किसके अगेंस्ट है? वो चलता है बेसिकली डायरेक्टर्स के अगेंस्ट, है क्या नहीं? तो कंपनी तो वॉलंटरी लिक्विडेशन में जा सकते हैं, कोई इशू नहीं है. वो बोल देगा दे विल मेक प्रोविजन फॉर दैट लायबिलिटी. अगर लायबिलिटी आएगी तो इन डिक्लेरेशन ऑल्सो इन एफिडेविट दे ऑलवेज स्टेट दैट इफ एनी लायबिलिटी कम्स आइदर वी हैव मेड सफिशिएंट प्रोविजन और विल पे. कोई इशू नहीं है. Now they have to attach the statement of assets and liabilities also. Suppose debts आपको list करना है ना, you have to give the list of debts also. Suppose there is some minor inaccuracy in those debts. Suppose 10 debts were there and you listed only 9. You forgot 1. तो क्या होगा? Whether it will invalidate the proceedings?
No.
ठीक है. Directors have a firm commitment from its parent company or some third party that it would cover any pending liabilities that the company on its own cannot discharge. Can such a company go in for voluntary liquidation? अच्छा, whether the declaration of solvency needs to be registered with ROC? जैसे चार्ज रजिस्टर कराते हो, ऐसे आपको डिक्लेरेशन ऑफ सॉल्वेंसी भी रजिस्टर कराना है क्या?
No,
Not
not
mentioned.
required. Not
Ah.
required.
Whether each debt of the CD must be listed in the declaration?
Yeah, it is
Yes.
to be
Yes.
attached. Yeah.
What is the liability of the directors in case of false declaration? Penalties. ठीक है?
Yeah.
Whether there is any particular form of notice for resolution? Notice का कोई फॉर्मेट है क्या?
No.
Can
नहीं,
in
there's no.
हाँ. Can a different liquidator be appointed in the meeting convened other than the liquidator whose name was initially proposed?
Yes.
So that can be done. All these are decided cases basically. Acha, suppose public announcement was made and some people, some shareholders, they are residing abroad. Now later on they claim that okay, we did not receive the public notice. तो क्या stand रहेगा? भाई some shareholders are residing abroad. अब बोले जी हमें तो पब्लिक अनाउंसमेंट का पता नहीं चला. They challenge this procedure, पूरे प्रोसेस को चैलेंज कर देते हैं. तो इसमें एडजुडिकेटिंग अथॉरिटी हैज हेल्ड दैट पब्लिक नोटिस इज सफिशिएंट. ऐसा नहीं भाई हर एक के पास अलग अलग नोटिस भिजवाएंगे आप. चलिए, these are some of the changes. एक तो डिक्लेरेशन में चेंज आया है, अभी जो रिसेंट अमेंडमेंट्स आई हैं रिगार्डिंग ऑब्लिगेशंस राइजिंग आउट ऑफ पेंडिंग मैटर्स. एनुअल स्टेटस रिपोर्ट का नाम कर दिया स्टेटस रिपोर्ट. और कंप्लीशन ऑफ लिक्विडेशन में भी कुछ चेंज आया है इन्होंने. पहले इट वाज 1 ईयर, नाउ इट इज 270 डेज और 90 डेज. ठीक है. Corporate voluntary liquidation, there is a change. So now they have made two types of payments out of this: prior to dissolution through the liquidator and after dissolution by the board. Filing of forms में भी आ गया कुछ change. Filing of forms में क्या आ गया? ये voluntary 1, voluntary 2, VL3, VL4. VL1 क्या है? This includes details of the corporate person, details of the voluntary liquidation process, etc. ये ऑन और बिफोर द 10th डे ऑफ द सेकेंड मंथ आफ्टर द पब्लिक अनाउंसमेंट. ये टाइमलाइन है आपकी. तो दे में आस्क क्वेश्चन ऑन दिस टाइमलाइन आल्सो. ऑन और बिफोर द 10th डे ऑफ द सेकेंड मंथ आफ्टर द पब्लिक अनाउंसमेंट. ये फिर VL2 है, VL3 है और VL4 है. अच्छा, इन केस ऑफ वॉलंटरी लिक्विडेशन व्हाट इज द टाइम टू सबमिट डिक्लेरेशन? डिक्लेरेशन कितने दिन में सबमिट करना है आपको?
Within 4 weeks, sir.
4 weeks क्या? 4 weeks from what?
From the date of commencement. From the date of commencement.
From declaration made.
मेरे को लग रहा है क्वेश्चन ही गलत हो गया ये.
Yes, sir. Sir, within 4 weeks of declaration, there shall be a special majority resolution.
हाँ, टाइम टू पास दी, इसको हमें थोड़ा चेंज कर देते हैं.
Resolution.
हाँ, let us change this question. So the question should be, in case of voluntary liquidation, time to pass the special resolution, है ना? To pass the special resolution or resolution,
Resolution.
है ना?
4
Within-
weeks from the date of
Within
Declaration.
हाँ, within
no,
dash
answer.
from the declaration. बस इतना ही कर सकते है ना। अब ठीक है। In case of voluntary liquidation, what is the time period within which a special resolution or resolution has to be passed? ठीक है जी, अब ठीक है। Is there any provision for withdrawal of voluntary liquidation application? Is law silent regarding this? हाँ जी। Voluntary liquidation में once the process has started, can you withdraw it?
Yes, sir. Yes, sir. Before the order of the liquidation.
Right. Before the order of
Liquidation passed by the
ये
adjudicating authority.
ए तो कोई ऑर्डर पास ही नहीं करता लिक्विडेशन को, डिसोल्यूशन करता हो तो बस।
डिसोल्यूशन पास होने से पहले,
लिक्विडेशन नहीं, डिसोल्यूशन।
हाँ,
डिसोल्यूशन से पहले।
टाइम लिमिट टू इन्फॉर्म बाय आरपी इज अपॉइंटमेंट टू ए विद इन, ये कितना है? ए को भी इन्फॉर्म करना है क्या इसको?
नहीं,
ए को तो इन्फॉर्म ही नहीं करना।
So yeah, liquidator होगा, right? Time limit to inform by liquidator as his appointment.
यहाँ पर बोर्ड
लिक्विडेटर को भी
और बोर्ड में कर
नहीं
देंगे
इन्फॉर्म
7
करना
डेज। बोर्ड को करना है ये 7 डेज में।
And sir, the RP term will change, sir, liquidator.
हाँ बिल्कुल बिल्कुल बिल्कुल। ये आरपी की बजाय आईपी कर दो इसको। So IP during voluntary liquidation found that purpose is to defraud the creditors. So what action he can take?
He can go to AA to suspend the liquidation.
Right. From which date commencement is counted in case of voluntary liquidation?
Date of
So,
resolution only.
resolution
Shareholder
passed.
resolution.
And suppose time period of liquidation is already fixed as per articles of association. So then, in that case, whether special resolution or ordinary resolution?
Ordinary resolution.
Ordinary resolution. ठीक है, चलिए। So I think we were able to cover this voluntary liquidation. In case you have any questions on this voluntary liquidation, you can ask. Otherwise, we'll continue tomorrow.
Yes, sir.
And I have shared some material also in the group, है ना। एक और क्वेश्चन बता दीजिए, चलिए छोटा सा क्वेश्चन है कि सपोज द कंपनी हैज गिवन सम गारंटी, ठीक है, फॉर सम अदर कंपनी। नाउ वेदर दैट कंपनी कैन गो इन फॉर वॉलंटरी लिक्विडेशन बाय XYZ is a company that has given a guarantee for ABC Limited. Now XYZ Limited wants to go in for voluntary liquidation. Can it go in for voluntary liquidation या नहीं?
डिस्चार्ज ऑफ डेट करना पड़ेगा सर उसको, जिसकी गारंटी दी हुई है उसका डिस्चार्ज करना पड़ेगा।
राइट भाई, या तो उस गारंटी को आप खत्म करवाओ पेमेंट करके,
या
है
तो
ना,
सबमिशन
या उसके लिए प्रोविजन करो, है ना। ये कुछ केस लॉज भी मैंने शेयर किए थे आपसे ऑन दिस।
सर कोई फ्यूचर रिसीवेबल है जो लॉन्ग टर्म रिसीवेबल बाद में ही आना है, तो उसमें ये वॉलंटरी लिक्विडेशन में कैसे कंप्लीट होगा फिर ये?
क्या
कोई रिसीवेबल ऐसा है जो बहुत लेट से आना है, बाद में आना है, 1 साल 2 साल के बाद आना है, कोई ऐसा रिसीवेबल है, लॉक्ड रिसीवेबल है कहीं पर आगे जाके रिसीवेबल?
हाँ
तो
हाँ,
वॉलंटरी लिक्विडेशन कैसे कंप्लीट होगा टाइमली?
रिसीवेबल में तो देखो इशू आता नहीं है। रिसीवेबल में वो तो कह देगा, डायरेक्टर बोल देगा हमारे पास आ जाएगा बाद में, शेयर होल्डर को ही तो बिलोंग करता है।
अच्छा, वो उस अकाउंट में चलता रहेगा जो
पेएबल की बात होती है, पेएबल में इशू आते हैं, रिसीवेबल में तो कोई दिक्कत नहीं है।
नहीं, पेबल तो कंपनी को पे करनी ही है, जो नॉन पेएबल है वो तो करनी ही है।
हाँ, तो
जो
ऐसे
कहीं से आना है
रिसीवेबल
तो।
में आ जाएगा, क्या दिक्कत है? अगर ऐसा कुछ है तो आ जाएगा।
हम्म।
रिसीवेबल में कोई इशू, किसी को दिक्कत नहीं आएगी। रिसीवेबल में किसी को क्या प्रॉब्लम? भाई देखिए ऐसा है,
नहीं,
एज
कोई
लॉन्ग एज
पे नहीं
क्रेडिटर्स
कर
आर
रहा
बीइंग
आगे से
पेड
समझ।
देयर फुल
हम्म।
क्लेम्स, तो क्रेडिटर को तो
हम्म।
कोई ऑब्जेक्शन है नहीं।
हम्म।
क्रेडिटर का तो पैसा दे ही दिया ना, बाकी रेस्ट ऑल बिलोंग्स टू शेयर होल्डर्स ओनली।
नहीं, तो वो बाद में लेते रहेंगे, जब आएगा तब
और
डिस्ट्रीब्यूट
तो
कर
कुछ
लेंगे।
मटेरियल रिसीवेबल है, आई थिंक तब तक उतना वेट करेगा कंपनी उसके आने तक का।
तो फिर वो वॉलंटरी लिक्विडेशन में जाएगा ही नहीं ना फिर
मुझे
इसके,
जाएगा ही भी नहीं, राइट।
क्योंकि टाइम है ना। टाइम तो देखो 270 डेज में आपको कंप्लीट करना है। इफ यू डू नॉट कंप्लीट इट विद इन 270 डेज, तो आपको कंट्रीब्यूटर्स का मीटिंग बुलाना है
तो
एवरी
फंड्स आने
270 डेज।
वाली है तो आई आई डोंट थिंक ये बीआर में जाएगा, बीएल में।
हाँ नहीं, फिर जाएगा नहीं। हाँ।
Sir, you have not answered 28(1)(h), sir. When a liquidator or RP can delegate his authority.
Okay, 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 okay. So, no, that was a question for you.
Yes, yes.
Actually, the point
What
here
is?
is
Yes,
that the IRP or RP has got certain duties and powers.
correct,
But section 28 says, 28(1)(h), it says that subject to the approval of COC, he can delegate its powers.
correct,
So this is what is given in 28(1)(h).
correct.
So what I was asking in the group was, what are the situations which you can envisage in which this delegation of authority is possible? Because appointment of professionals is separate provision, है ना?
Correct,
For
correct,
appointment of professionals, there is a separate section.
correct.
So what do you think can be covered under delegation of the authority? So under delegation of authority, you have to refer to section 18, 20, and 25.
Yes.
So section
It's,
18, what it says?
it talks about his duties,
Right.
political claims, so many
And
things.
section 20 talks of management of operations.
Yes,
And section 25 talks of the duties of the resolution professional.
correct.
Now the point is, what is covered under section 28(1)(h)? Delegate its authority to any other person. अजय जी, क्या लगता है आपको, क्या हो सकता है इसके अंदर? Delegate its authority to any other person. What could be covered here? So what I
Sir,
can
I
think of is, मुझे क्या
Yeah.
लगता है,
Health issues.
हाँ
Health issues.
नहीं वो तो ठीक है, वो भाई क्या, हाँ
Sir, I can imagine this.
यस
Suppose, you know, you are interested with running the company as a going concern,
राइट
and there are certain technical things you cannot handle, right?
राइट
You require the company management or people to run this, right?
नहीं,
To
मैनेजमेंट यू
run
कैनॉट
the
इन्वॉल्व इन
operation.
CIRP. Directors you cannot involve. Directors, KMP, no, their power is suspended.
Not directors or KMP. I'm
Okay.
using the employees only. For example, certain head of the departments are there. I'm forming a asset preservation committee or something, right? I want to run, but I don't have the expertise myself, right?
Mhm.
Sir?
Sir,
See, I
anytime
can't.
we can appoint professionals, there is no bar.
हाँ, वो तो प्रोफेशनल हो गया ना.
Professional and technicians we can appoint anytime.
This is something above
Delegation is
professionals. ये
something
कुछ और आ गया.
personal, very personal, I believe. If the RP or liquidator believes that he needs some help or some person who can look after his matters because he's somewhere busy or something, not looking after completely. The work is very vast, so he may delegate some of his portion to the other person with the approval of the COC or the
Sir, I
stakeholder.
remember, sir, I come across a case which is
But he will be liable.
Yes,
Sir,
Yeah, 100%.
Ultimate responsibility will be-
Ultimate responsible rests with the delegation is only delegation,
Hmm.
but the accountability is with me.
Hmm.
And I remember a case of Jet Airways.
Yes.
So I give you an example of the Big Four, how the Big Fours they work under this CRP IBC mode. Actually, the appointed employees who are working under the RP or liquidators use the signature, the team member of the RP or the other things, and below their signature, their signature of the RP also. So
Hmm.
this is how it works actually. Declaration is very important.
Okay. Hmm. ठीक है.
So
नहीं ठीक है. I agree with you. कुछ मटेरियल भी मैंने शेयर किया है. प्लीज गो थ्रू दैट मटेरियल ऑल्सो, है ना. बाकी फिर कल करते हैं.
okay, thank you sir. Good night.
कल हम लोग क्या करेंगे? इंडिविजुअल इंसॉल्वेंसी कल करते हैं. फ्रेश स्टार्ट, है ना.
Okay.
Right, sir. Fresh start.
फ्रेश स्टार्ट कर देंगे. पेनल्टी प्रोविजंस यू
Yeah.
कैन गो थ्रू ऑन योर ओन.
Correct.
उसमें कोई खास बात
Correct.
नहीं है ना.
Correct.
तो विल कवर द प्रोसेसेस फर्स्ट, है ना. तो कल हम प्रोसेस स्टार्ट करेंगे अपना ये
Right.
फ्रेश
Yeah.
स्टार्ट.
Yeah.
ओके.
Okay, sir. Thank you.
ओके.